there is no person identified. And I really want to make a fine point of this. No one is accused of doing anything in this affidavit. It's now public. You can see the basis of the seizure of hundreds of thousands. Every single 2020 Fulton County ballot was seized on the basis of an affidavit that doesn't accuse anyone of taking any criminal action. It says if a certain action was taken, that would potentially amount to probable cause. And Abby Lowell says that converts the standard to possible cause. And to get out of the weeds here and give it the big picture, we are 6 years after there was a 2020 election. We're nearly more than 5 years after that election, and this is still an ongoing effort to relitigate the history, but it's even more than that, because some of the issues that are being debated in court right now, for example, does Fulton County have a Fourth Amendment right to protect with these ballots against unreasonable searches and seizures? The Trump DOJ says no. And if a federal judge finds that is correct, Abby Lowell pointed out, they can do this in hundreds, if not thousands, of election locations. And there wouldn't be a court in the country that, if there is no property interest, if there's no Fourth Amendment right from the county to protect these ballots, as the Trump DOJ argues, there is any number of locations can be targeted. So that's why I'm down here in Fulton County. That's why I flew down to Atlanta in the federal court behind me, because this is more. This is about more than the objective in this case, which is a return of the ballots. There's also whether this can be replicated, and if so, what standard, if any, does the federal government need to meet?
I have so many questions, starting with, it sounds like the magistrate who signed off on the warrant didn't really do her job. And I mean, I don't want to be critical of somebody I don't know, but when you think about this last week, when Judge Boasberg said, when the government wanted a search warrant to go after the Fed chair, he said, "What are you alleging went wrong?" And they said, "We don't know, nothing. We're going to look." And he quashed it. He said, "No, that's not how the law works." And it sounds like here they got away with that.
Right, and that's where the district judge is supposed to oversee the magistrate. That's an argument that Abby Lowell's making right now, and saying she was wrong on the law. But even if you find otherwise, that there were things that were not disclosed in that affidavit. They disclosed, for example, that this investigation began on a referral from Kurt Olson. It does not disclose that Kurt Olson was sanctioned for lies related to the 2020 election, as Abby Lowell points out, not once but twice. So were those, what the standard that the judge is going to need to rule on is, was there a callous disregard for the county's rights? And if they failed to disclose very pertinent information, Abby Lowell is arguing that can rise to that bar. Good. And right now we're seeing witness testimony from an election expert who's going line by line into the affidavit and what it is claiming. I'll give you an example. One of the things that we've heard testimony about is pristine ballots, because what you're seeing with a lot of these witnesses is a relitigating of rejected 2020 election conspiracy theories. And one of them was the idea of pristine ballots, which means they were that when certain ballots are absentee, mailed in, that one would expect a fold or a crease, and the government says, aha, there is no fold, there is no crease, this is pristine, and therefore it's misconduct. Never mind the fact that Brad Raffensperger, the Republican Secretary of State, looked into this very issue and concluded pristine ballots, the ones that are being talked about here, this was thoroughly investigated, these ballots weren't counted. That isn't in the affidavit. And so this is the type of testimony we're hearing. If this investigation if these ballots aren't returned, if the investigation that the Trump DOJ is pursuing leads to an indictment, one can expect the reviving of these conspiracy theories, and that's why it's so important to get into the weeds.
So, Adam,
what's going on?
Let's talk about the Fourth Amendment question. I mean,
right.
The government is arguing, I guess, if they're saying the Fourth Amendment doesn't apply here, they're saying, what are they saying? We don't even need a warrant. We can just take. Is that what they're saying?
It's a very perceptive question, because that's exactly what Abby Lowell said that the effect of that would be. As a matter of fact, one of his arguments against the Trump DOJ's claim that counties and election administrators don't have Fourth Amendment rights to protect here. Well, if that's the case, why did you seek a warrant from the magistrate to begin with? You could just have, you did not need it under that theory. And the fact that they pursued the search warrant is itself evidence that they know
they need it. Yeah, but the administration's point, I think the president's point, wrong as it is I control elections in America. They are mine. You're all agents. He said this, my agents in elections in the country. That is absolutely legally wrong, constitutionally wrong, and besides just a damn lie. But this is but if there is no protection of anything and the federal government can come take it all, de facto, it's his.
Absolutely. I mean, that's the inverse of the case. As we know, states administer elections. And one of the important arguments, they're trying to get into the weeds, for example, of why do you need the originals back? Now, I want to establish right now, both parties have the federal government's photocopies of the originals. Now, let's say the federal government says, aha, we found 6 years later some horrible defect, and it shows that it was rigged. It shows that these were, as Trump put it directly, crooked ballots. The Fulton County says this is an election year. We're responsible for responding to the barrage of conspiracy theories and claims like that. We can only do that with the originals. And those originals, for whatever reason, the government is refusing to hand back. As a matter of fact, before this hearing began, there was a discussion within the federal government that they would return the original ballots, the original copies. They reneged on them.
Well, of course. Once this government has something, it's going to ask for something else. But once the chain of custody is broken, I don't know that anybody can trust them. Who knows what this Department of Justice is doing with those ballots when they have them in their control?
Absolutely, Edwin. And as a matter of fact, I've spoken to one of the Fulton County commissioners who raised that very concern. He said it's in Pandora's box. You can't put Pandora back into the box once that chain of custody has been disrupted. Yet those are still the stakes, and even more than the stakes of will these particular ballots be returned? Will Fulton County be armed to respond to the fire hose of misinformation about the election in a timely manner? Setting all of that aside, the legal precedent here is what's incredibly important. If a federal judge endorses the idea that no county has a Fourth Amendment right to protect when the federal government comes knocking, well, you know what's going to follow with that. We are in an election year. If the federal government claims this absolute right to take whatever ballot they want from state administrator, that takes us to a whole different level.